starting to lose count, but not lose focus. We've got a busy agenda this morning, and we're also happy to welcome Representative Morey from Working Group 3. Working Group 3 has already considered several proposals very consistent with some of our work, and will continue to do so. We're especially tracking their work on juvenile life without parole, and such consistency between our work on extreme sentencing and their work on the court system. So thank you, Representative Morey. Welcome to the session, and hope to hear your comments and observations through the morning.
Thanks a lot, Henderson. Good morning, everyone.
First, I hope everyone's had an opportunity to review the minutes, and we'll allow this time for any questions, concerns, or edits to those minutes. Seeing no concerns, I'll entertain a motion. Please.
So moved. Move to approve the minutes.
Thank you, Mary. Is there a second?
I second that we approve the minutes.
Okay, thank you, Brooke. All in favor, say aye.
Aye.
The motion carries. Thank you. This morning, we've got several things ahead of us. I guess most substantially, an opportunity to discuss and review the proposals regarding the Second Look Act. We started this, we engaged substantively in this conversation a week or so ago with Dr. Nellis from the Sentencing Project. And we have attempted Dr. Nellis kindly offered us some draft thoughts, and we've added to those draft thoughts. And Mercedes, where are our latest documents stored?
They are on the SharePoint. And so I can share a link in the chat now, and then also they're there. I'll send a link after the meeting.
Okay. And apologies for the lateness of sending this draft. I had some hopes of having this to you before the weekend, so that people would have more of an opportunity to read through the draft, give consideration to the important provisions of this proposal. And having cheated you of that weekend, we're going to try to do the best we can this morning to highlight some of those provisions, and to request that folks spend some time thinking over the next few days about these provisions. I think fortunately, because of our earlier discussions, we're hopeful that we may be in a position at the end of the day, at the end of this morning, to agree upon some basic principles regarding the Second Look Act, and that we might be able to put off some of the very, very specific provisions until later in our process.
I am having some trouble sending the chat for some reason. I am sorry about that, you guys. I'm going to ask somebody in the background, maybe Ellen, Jasmine, if you could drop that in there. Apologies.
Sure.
Thank you. So not sure if what we did do is break down the recommendations into slides. And so hopefully we can kind of go through them one by one. And what we did at first was we basically, if you see, once you have that document pulled up, and or just follow along here with the slides, we broke the recommendations into kind of three general populations. Basically, the reduction of racial disparate in sentences for through the review of those who are currently incarcerated, looking at increasing DPS's flexibility on incarcerated individuals' release dates, and then addressing future sentences to reduce racial disparities. And so going to the first set of recommendations having to do with reduction of racial disparate sentences through the review of those currently incarcerated. We had, I believe, 3 recommendations that fell under this. And so Henderson, I don't know if you want to take it off from here.
Right. Let's pause at this first one. The state has been engaged for well a decade or more in the review and interpretation of the Racial Justice Act, based on a tremendous research study by professors at Michigan State Law School. The evidence was just overwhelming of the discrimination against African American citizens and their service on juries. And so as a result of decisions this summer, the Racial Justice Act will be available to those who had filed petitions prior to the repeal of the Racial Justice Act in 2012 or 2013. And what this recommendation is would cover those petitioners or those prisoners who have not been able to file a petition under the RJ because of the repeal. And since the Supreme Court did not address the constitutionality of the repeal as applied to prospectively, there is a small class of individuals who are currently on the row who don't have access to the Racial Justice Act. And so what this recommendation would be to reinstate the RJA prospectively. The second provision reflects the fact that we're in a dynamic state. North Carolina's Racial Justice Act served as a beacon of light nationally. And so one of the states that took the Racial Justice Act that we had passed as a model for their justice system is California. And when attempting to review their justice system and our act, they decided they could do more, they could do better. That the same principles that animated the Racial Justice Act for capital cases applies equally to non-capital cases. It's sort of the reverse of the McCleskey decision. McCleskey was, the court was unwilling to do too much justice in McCleskey and sort of closed its eyes to the role of racial disparities because it would sort of undo too much within the system. Well, California said, well, the problem of racial disparities don't stop with the capital system. We ought to extend it beyond that. So the recommendation that we're making here is that we give serious attention and consideration to the proposal in California to make an RJ applicable across the board. We make it in this sort of request for further study because we simply have not spent the time. And it would be an incredible undertaking to think through what the challenge would be to extend the RJ across the board. So while it's not a fear of us doing too much justice, I think it is a concern that we take in more information, that we have more of a sense about how that would impact our legal system before making that proposal formal. So the recommendation here is to give study, and so that the continuing efforts of the working group and or legislative committees with authority over these claims would give due consideration to it. The third issue is, a third recommendation is to create a clemency initiative. And what we're trying to do here is to embolden and and equip the governor's office with the capacity to exercise this traditional power, and to invite that process to include the participation of other important stakeholders, including among these stakeholders, family members, individuals, and communities that are most directly impacted by the harm, reentry organizations that are working with offenders and with communities to make the reintegration successful, and of course, the lawyers, both prosecutors and defense lawyers. So again, this is a proposal that is aspirational. It is at a fairly high level and does not have the specific plans for implementation attached at this point. I'll pause here to entertain any questions or thoughts, and invite members to reflect or comment on these three recommendations. Okay.
Henderson, let me ask you about the number 3 there. Where did that initiate, and how do you see that playing out?
Well, one prompt was the Clemency initiative that was established towards the end of the Obama administration. I believe it was 2014. And so at the end, I think Obama granted clemency to a record number of individuals. And so there was a lot of thought that that initiative made sense to redress a system that was overly retributive. And so one thought was, can we just sort of transfer over what the feds had done in their statute? I think that initiative was 5-6 years earlier. And I think there's been a lot of thought given to the issue of executive power and how it should be exercised in the clemency context. And so one concern was not to look with too narrow a focus. And so Obama's plan, the federal plan, was restricted to folks with largely no criminal history, largely drug offenses, almost exclusively non-violent offenders. And I think one of the ways that this discussion has grown over the 5 or 6 years is that we should not have rules that, ab initio excludes the participation of folks who have violent convictions in their history. And so this charge is a call to create and to empower that clemency office. But I think further details will have to be worked out in terms of the standards that should drive or inform the operations of the clemency office.
So we previously recommended enhancing the funding and and the number of individuals involved over there, the manpower at the office. So this would enhance that.
It's consistent. It's certainly consistent with our prior recommendation, but I'll defer some to Mary on this. But I thought our prior recommendation was a first step. It was some initial expansion of the staff, enabling it to sort of carry out the mission of the office, to respond to the emergent situations of COVID-19. This recommendation is a bit more longer term in view. Let's start charting out how the governor can be a more proactive actor in redressing the effects of mass incarceration.
I think it would be more acceptable to the community at large if you had these stakeholders involved rather than just having the governor wield his stick. Of course, you have different administrations with different philosophies on these issues. And if you had a standing set of guidelines that involved stakeholders, I like that.
Yeah, I do too. I think this is I think a broader initiative than I had envisioned. I sort of wanted to get the office up to where it was performing its traditional function, and this is a broader function that arguably could really result in clemency for more people. I wanted to just talk a little bit about recommendation number 2, because I'm having a hard time kind of visualizing what that would look like. And I wondered if there was any thought given to looking at the felony murder and whether that's resulted in racial disparities in serving people in sentencing people to life without parole, and whether that's a repeal of the felony murder law, or, you know, felony would result in a kind of the same result. I don't know.
Well, I think it's a good instinct that you have to scratch your head about how number 2 would be implemented. I have been in conversation with several colleagues in California that are looking at this implementation question, and there are challenges to it. And so I think why this is listed in this sort of aspirational terms is that in principle, it's hard to think of why the principles behind the Racial Justice Act should be limited to capital cases. But how you implement that in non-capital cases presents challenges. It's a different approach than what our RJA is. So, Mary, I think my short answer to you is we are stuck now with the impact of the felony murder rule. That's a knowable thing, and how to fix and address the effects of the current application of the felony murder rule is something that we could would be easier to do something about. So I sort of take that as a friendly recommendation, and I think we ought to think about how to sort of move that forward. So thank you on that. Mercedes, the next slide.
Henderson, I know we were trying to kind of maybe avoid doing another survey, like a working group survey, in order to kind of push this along. So I'm wondering if y'all want to maybe poll, I don't want to put anybody on the spot, but maybe poll on where we're at with where these are moving forward to going to straw poll to the task force. If you guys want to do the survey offline before we go to the next ones, or however you guys want to proceed.
Well, using the sense of consensus that Karen had introduced early on, do we have consensus on 1 and 3, that those are recommendations that we think are recommendations that we feel comfortable could be passed along to the task force? And on 1 and 3, are there any concerns that would prevent us from, at this stage, moving it along?
I don't hear any.
Okay, so I think we got consensus there on 1 and 3. Mary, I think your notion is a good one. I wonder if you could, hate to put more burden on you, but it might be helpful for us to try to reduce that to a recommendation, which even at this high level, we could sort of pass on at the next time we elevate things to the task force.
Okay. I do think it would be a kind of a recommendation separate and apart from this one. So I'm curious if there's consensus on number 2, and then maybe we present, Mary, you can kind of draft something up. We can work together to see what we can do and pull y'all offline on that. Is that?
Well, I guess on number 2, the more I reflect over it, the harder I think it is to give that meaning at this point. But I would yeah, I would defer to the members on that. I see that it might be too vague to have very much significance at this point. And I'll ask the members what if they've got any sort of contrary views on that.
I would agree.
It's not something I can make a decision on at 8 a.m. without thinking about it a little bit more. Is that fair?
I think that's fair. And my only concern is, Mary, maybe even at noon.
I have a hard time. I guess if we're going to present recommendations to the task force, I guess I have to be able to kind of view how we explain it to them, and I can't really articulate it to myself right now. Right? I get the concept of it, but where does it go? Right? You have RJA, and does somebody's life without parole sentence? Then are they tried for a different crime? Does there, I don't know, is there a first degree conviction? I don't know. There's just so many questions that come to mind. I feel like when I talked about the felony murder issue, like that's one kind of concrete thing that we can identify whether it's resulted in racial disparities, which I imagine that it has, and then address those. That's a pretty specific or definable fix, I think. So I don't know. I think we have consensus on 1 and 3. Is that
okay? Fine. Okay. Well, so going on to the next. Perfect. So, and there's the fourth one. And this is the establishing a statutory process that allows review of individuals sentenced as habitual felons.
Yeah, I think there was nothing that came out with greater clarity than the racially disparate impact of our habitual felon and violent habitual felon laws, both in that the extreme nature and consequence in terms of sentencing, and also the extraordinary amount of discretion in terms of when to apply that criminal history to invoke the sentencing provisions of the Habitual Felon Act. And as I recall the numbers from the sentencing project that Ben Finholt shared with us, I think at the violent habitual felon level, 80% of the population serving sentences under VHF were African Americans. And that was just an extraordinary level of disparity, which raised the special concern that it came in the context of unreviewable discretion, really uncharted discretion as to when to apply the statutory provision and when to waive it. And so I think dealing with that is a real urgent matter if we're going to advocate for racial equity.
How would that be done?
I think there are a couple of ways that it could be done. One is just to eliminate that provision for violent habitual felons. And the other way would be to establish some guardrails on its application. I think the problem with guardrails are, they tend to expand the number of people that are subjected to this kind of sentencing regime, so that eventually where we are going to come out on is elimination of the habitual felon rule.
Yes, go ahead.
Phone call with a stakeholder the other day that was mentioning how I think certain jurisdictions have a process where DAs it's a committee of DAs. Obviously, it's a question of resources by jurisdiction, but a panel of DAs will review when habitual felon is charged, as opposed to allowing it to be used as part of the plea agreement, right? And so I just wanted to throw that in there.
So is this anticipating looking back or changing the law going forward?
This
This would
provision,
be a review of the charging decision?
As it reads, it applies to looking back at those that have been have been charged as habitual felons. But I think it could kind of be read both ways. So we might need to wordsmith that a little bit if we do want to proceed with it. Because
I'm more comfortable looking at how it's applied going forward, and I think that's what Henderson was getting at, and I agree. It's the data is fairly startling when you look at it. I think it would be easier for people to grasp if you tried to go look at how it's applied going forward. I don't know if that's what you were thinking about, Henderson.
Yeah, I'm thinking that the sort of traditional or the more core Second Look Act can be effective in redressing past extreme sentences. That we create a provision for the court to entertain information about institutional adjustment and the sort of broad areas that would be relevant to a second look. But I think this use of habitual felon provision is most productively a perspective tool.
And Henderson, this is Jasmine. There is, just for everyone's situational awareness, a separate recommendation that comes later in the slides related to future sentences that addresses just that point. So I think the idea here was just a question of whether the working group wanted to have this particular sentence type have, specifically called out for review. So that, as Henderson said, could also be something that happens as a part of the Second Look Act.
Well, I'm sensing for purposes of clarity, it might not be helpful to pass this recommendation on independent of the broader sentencing review process that we're going to get into later. Is that the sense of the members and just sort of looking?
I think that, so the Second Look Act, and I see the slide is up now, that would grant prospective relief to all of anybody who was sentenced as a violent habitual felon, because that's a life without parole term. I wonder, that provision is used so relatively rarely. I wonder if it just ought to be repealed, right? Violent habitual felon, it's rarely used, and when it is used, it's used in a markedly discriminatorily fashion. And I don't know if we're discussing that at all, down the road. Repeal of violent habitual felon and some sort of look at how at habitual charging. I don't know.
I was struck with the presentation from the Sentencing Project, Ben Finhall, that if anything was sort of irreparable from a theoretical point of view, it was these violent habitual felon or the habitual felon provisions. And it was hard to imagine, how do you fix it? And, do we have does anything in the history of that provision and its implementation give us any confidence that it could be fixed? And I was struggling all through that presentation to imagine how one fixes it. And I think the last point that Mary raises, that its relative use, the frequency of its use is really not great, so that when it's used, it's almost only used to aggravate the issue of racial disparities. And so the wiser course may be just to eliminate that provision. So Mercedes, I think we've got our work cut out for us a little bit, because I think the better recommendation here would be to eliminate the Habitual Felon Act. And
I have notes now that we have
say that again, Mercedes, I can't hear you.
notes now that we have two recommendations here, one for repealing of felony murder and repealing of violent habitual felon. So we can take those offline and
Right.
maybe move here to looking at what we've got for establishing a second like that.
And this is sort of one of the basic principles that we want to have some discussion about. Dr. Nellis offered a draft where she talked about review of sentences after 10 years. And we have in our discussion point, our share point, a handful of other jurisdictions that have done some work in this area. And they do range from 10 to 20 years. And one thought we had here was that the language here, 20-year mark or before, opens up the opportunity for the proposal to be clarified. For example, if there's going to be second looks at property or drug offenses that are nonviolent, it might be that there be a rebuttable presumption that 10 years should be the maximum. For violent crimes, for homicides, the rebuttable presumption is much more likely to be at the 20-year mark. And so it was helpful to get that very good start from Dr. Nellis. We did, as you can see in the SharePoint, add to it with some additional national efforts. And the thought here is if we're going to make a recommendation to the task force, the language in the first bullet gives guidance and can be further fleshed out as we give more consideration to the actual legislative proposal. The second provision is one that may or may not benefit from some additional consideration here. I did not see that particular provision in any of the other national proposals, though I understood that there is something similar to that in DC. The thought that that sort of motivated this is if you've got 10, 15, 20,000 petitioners, that's an awful lot of petitions coming in for sentencing review. And if you look at Rule 35 motions in the federal system, if you look at some habeas practice in the federal system, if we have certain standards about under what conditions a sentence can and should be modified on review, should we have a threshold showing that has to be made before a petitioner is entitled to counsel to help litigate the system, to help litigate the petition. And so we added that provision for folks to think about to determine whether that's a helpful addition to what we've seen in other proposals.
I think in terms of making it manageable for, presumably these petitions would go to Superior Court judges similar to a motion for appropriate relief, you would have to have some sort of a screening or a threshold like you do with the MAR statute. If you don't make a certain showing, you're just dismissed as being frivolous. And if you do make that showing and you're entitled to an evidentiary hearing, you're entitled to appointment of counsel. So it makes sense to me that there does need to be some sort of a threshold and a screening mechanism or something in place to to make it a manageable process. So,
And the last bullet is an attempt to identify some of the standards that would inform that threshold. Some of the showings that would be required for the petition to proceed closer to an actual review, hearing, or determination. So those seem to be the essential provisions of a second look act. Undoubtedly, by the time you get towards legislation, more will need to be done to flesh it out. But let's try to get a determination of whether people feel comfortable that a consensus can be found for recommending a second look process such as this, and or what concerns we might have with going forward. Mike, I see a non-verbal. Okay.
Like Mary, it's 8 o'clock in the morning. I've only got a limited number of words that'll come out right now.
Okay. Well, we'll take that thumbs up as a loud note of consensus.
Yeah, I think it's a good start.
Good. Thank you, Mercedes. Yeah, we've added into the chat, not into the chat, I guess it's into the SharePoint, just some bullets that I was able to come up with from other jurisdictions that have walked down this path. I think the District of Columbia is the most developed. It's much of the focus is on youthful offenders. I think the recommendations center on those under 26. But there's these other provisions that one can look at to take some guidance from, and certainly as the recommendation goes forward, keeping a lookout on these sister states and how their provisions are developing would certainly make good sense.
Okay, so these next series of recommendations have to do with increasing DPS's flexibility on the individual's release date. And these have to do mainly with a lot of the programming that is provided. So the recommendation as it reads now, Henderson, if you don't mind me reading it, is recommend the expansion of access to and funding for DPS programs currently enforced to release incarcerated individuals, such as extended limits of confinement and all manners of sentence credit programs. Also eliminate the revocation of post-release supervision for technical violations.
Now, these recommendations came after some specific discussions between the staff, largely Mercedes, and the staff at DPS. So Mercedes, why don't you take an opportunity now to at least summarize some of those conversations and why the DPS staff thought this was important enough to bring to the task force attention.
And I'm going to rely heavily on Ellen and Jasmine to talk on those meetings as well, because they were a part of it. And so ultimately, my understanding is that these are currently programs that are being utilized to their max in order to respond to the COVID epidemic. And they are eager to do more, but they don't have the funding. And so there's the funding question, and then there's also expanding access to who has access to the extended limits of confinement and the credit program. So making sure that those programs are more accessible to a broader range of individuals. And then eliminating revocation of post-release supervision for technical violations obviously is going to result in less people going back for minor violations. And I don't know, Jasmine, Ellen, do you have anything to add on that? The second one, there's recommending the creation of a task force to examine racial, disparate access and outcomes associated with the work. I think that is something that they are looking to do.
Last week, Representative Murray had Working Group 3 invited some discussion about reimagining the justice system and the role of restorative justice, some big picture thinking. When I think about that sort of big picture thinking in the context of the Department of Public Service, people can entertain thoughts like, abolishing prisons and, some dramatic conversations about how to transform how we respond to crime. I thought it was interesting to hear from those inside the Department of Public Service who are feeling a need to reorient in significant ways their operations, but feel handcuffed, feel like they don't have the authority to do some significant changing of the system away from pure retribution, punishment, and incapacitation, and towards something that's more restorative, more designed to facilitate reentry and return to community in a productive way. And so that's why I thought these proposals seemed to be friendly to the larger mission of the working group and the task force. And the fact that they came from sort of inside DPS sources seemed encouraging. But I really look to the members to share their thoughts and concerns. Mary, are these the points of discussion that you're familiar with in the past? And does your experience inform any of that?
Yeah, I think Jasmine had some input that I'd like to hear, and then I may or may not have a thought.
Yes, I just wanted to just provide the extra context. Folks we talked with were very clear that that it is very difficult to do the work that they are currently trying to do on the staffing that they currently have. They were very clear that they would need double the staff of social workers, screeners, and they also were very clear that, and this is related to your collateral consequences recommendations, that our reentry landscape needed to greatly improve, as we all know. So I felt that very powerfully in the conversation that we were having. We also, related to number 2, had a conversation about, to the extent that these are discretionary programs, where are the places where inequity may enter into the discretionary decisions, and just kind of had a brainstorming session about that. And I want to be clear that they were not recommending something specific, but were identifying issues. And so that's where these recommendations came from. And so that's where number 2 comes from. But to say that at these points of discretion along the way, where, how can we make sure that we are not recreating disparities that also exist elsewhere in the system? One example came up is if you're getting credit for particular types of jobs, right? If you're getting release-related credits for particular types of jobs, who gets those jobs? Who gets access to those credits, and so can therefore have their sentence reduced. And so that was also the spirit of where this was coming from as well.
I mean, I think this is, I know that DPS has struggled to have sufficient jobs available and sufficient programming available and sufficient different kinds of programming available for everybody to be able to work their way down to their minimum sentence. And that's problematic. I had so many clients who just wanted a job, they wanted to work and there was nothing available to them because DPS didn't have the resources to provide the jobs or to provide that kind of programming. So I'm 100% behind both of these recommendations, and it is a resource issue, I believe. I think this is really important.
Yeah, I would agree. And I think these have probably broader community support than some of the second look issues. And it's an efficient way of dealing with it. I mean, you're talking about increased staffing and some resources that bringing back individuals before a judicial panel or something like that. I mean, I assume there would be some overlap in these type of proposals, but I think we're getting a lot of folks coming to the court and not really knowing what they're asking for, and then we talk about the extended limits of confinement, and as Mary and we have found that some fit and have been released under that program, and they, so I think it's a good way to deal with it. And it has a lot of community support, anecdotally.
We're running pretty quick on time, so I'm going to go through. It sounds like we have consensus on this. Got nods. Okay, so let's get going to the future sentences.
And Mercedes and Henderson, I wanted to remind folks or let folks know that Michelle Hall and John Madler from the Sentencing Commission are on the line as well. So if people have questions, they are available and a resource.
Yes. Apologies for not doing those introductions earlier on. So Henderson, do you want to run through these next handful of recommendations?
Well, I think this next one refers to principles that we've already discussed. In point 4, eliminating future use of habitual felon status. I thought that we had consensus on that. The first bullet is our recommended provision regarding the second look at 20-year or before mark.
And that's, yeah, and I think that is a recommendation that for all future sentences going forward include a 20-year review by judges.
Number 2 is an acknowledgement that the Sentencing Commission houses the most muscular capacity the system has to evaluate the data. And that we are recommending that commission use those resources to return a report that recommends how we can move methodically and equitably to redress some of the both unintended consequences of the sentencing revisions and to inform our sentencing by our new or more fully developed sense of values that the system should have. And these values are different than what they were in 1994. So it's a charge to the Sentencing Commission to report based both on the data that they have and to both inform the value selection that our sentencing scheme should have, and to do that within a year.
And yeah, the origins of that, I think, was kind of the idea was expanding the executive order talks about working with the Sentencing Commission, so it's expanding on that provision of the
Very good.
The next one has to do with expanding advanced supervised release use, which is something it allows incarcerated individuals to actually be released before their minimum sentence. And it also includes an education campaign on that. That isn't something that already exists, but is what we understand to be underutilized. And I'm not sure if there's anybody that wants to share any thoughts on that. And
I would just add one additional context point on that. This is I think related to the DPS expanded flexibility point as well, because no matter what DPS does, unless someone has the use of advanced supervised release, no one is ever getting below 100% of their minimum sentence. So I just wanted to tie those two together. That is yet way to provide some additional flexibility if people get this type of sentence under current law. And don't know if the Sentencing Commission folks want to weigh in there as well.
Good morning. This is Michelle Hall. Hopefully you all can hear me, Executive Director of the Sentencing Commission. ASR is something that the Commission has looked at several times since it was enacted under the Justice Reinvestment Act, sort of from a variety of angles. One was trying to somewhat investigate why the use of it was so limited. And, when we looked into that, we found that although, individuals might be eligible in a large number of cells on the felony punishment chart, there was a lot of confusion, at least at the time, among defense attorneys, prosecutors, and judges as to who the right candidates were for advanced supervised release. And defense attorneys weren't keen to go for it versus another potentially more favorable plea because their client would still have to complete the programming while incarcerated. So it just made it less of a sure thing. So the commission had sort of looked at some potential improvements that might have helped, increase its, usage, but and one of those was sort of making it more clear who it was intended for, potentially beyond just you're eligible because you're in this particular grid cell on the chart. But that didn't really go anywhere. Of course, the commission being an entity that is very big and founded on the principle of truth in sentencing, the possibility to go below the minimum sentence is a concern. But those are just a few sort of off the top, thoughts about ASR, and we certainly could provide data. We look at the convictions imposed every year under this provision, and then we also look at prison releases that were released at their ASR term, every year. So we could provide the working group some data on that if that would be of interest. And I can follow up with Mercedes or Jasmine or Ellen about that. I don't know if that answers your question, just a few thoughts about ASR generally.
Well, they're helpful to me. One of the things that you mentioned was a thought that I had that one problem might be just the level of knowledge that the defense bar has about ASR, and whether or not public defenders in particular need more training on this subject. But one general principle is that sentencing options and post-sentencing options are among the least well-known territories of practice for the criminal defense bar. And I don't know, Mary, if your experience is different, but there are a very small set of lawyers with specialized knowledge about post-conviction programs and those that affect service of time. And so one of the challenges may be growing the information base of defense counsel on this important area. But I think all of these recommendations are themselves seem very sound, and I would recommend that they go forward. Any additional comments on this slate of recommendations?
Number 4. So is that? Have you had any?
We didn't touch upon that one yet, but that would be as it's written, eliminating the future use of habitual felon status. And that I don't know if that we might wordsmith that or have that as it is if it has the support. in conjunction with the recommendation that Mary made about repealing violent habitual felon status.
I might like to have a little more time offline to talk about both of those.
So let's take 4 offline.
Well, we have the Sentencing Commission folks on the line, though. I don't know a whole lot about the history of the implementation of structured sentencing, and other than that it happened and what it looks like. But it seemed to me that the theory of structured sentencing is that you have a prior record level that's tied to your past behavior and your past convictions. And at the time structured sentencing was passed, was there any discussion about eliminating the habitual felon law? Because it sort of seems almost duplicative in a way. So I don't know. I feel like there's some. Well, we'll take it all offline, but I feel like there's some need to revisit structured sentencing in a way that makes habitual felons law not really something that people need to use, since it's used in a discriminatory fashion often.
Mary, this is Michelle Hall, Sentencing Commission. I might toss that question to John Madler. He's sort of the historian on the structured sentencing development. And I think, you know, the habitual felon status, whether that was, I think it was new at the time that structured sentencing was being developed, so they didn't really do anything with it. But I prefer if John answer that question, because I think he had some information about how that didn't necessarily fit in with the structure that was being developed at the time.
Yes, this is John Madler. Mary is right. It was discussed during the development of structured sentencing, and the issue was that there is prior record calculation built into the grid. It came down to a final vote, and it did pass by a very slim majority. So there was a large portion of the commission that was in favor of eliminating it, and then there was a slightly larger portion that decided to keep it and to go forward and see how that worked in conjunction with the structure.
Mary, this is Jasmine. We also talked with, we also talked with Jamie Markham at the School of Government about this, and he wasn't able to be with us this morning, but also said he'd be available for questions afterward. I think he has some historical context on this question as well.
Okay. I was just saying thank you to John and Michelle for their insights. Thank you.
Oh, so that was the last one. Okay, well, it sounds like we made some really great progress, and we were like almost right on time.
Let me just ask John and Michelle, you know, we heard those numbers of the 80% African Americans sentenced under the violent habitual felons. Is that consistent with the data is that the same numbers that the Sentencing Commission tracks, or is that something that you track?
Michelle Hall again. We do publish convictions and sentences imposed information on an annual basis as part of our structured sentencing statistical report on felony and misdemeanor convictions. And I will say, I think Mary may have said this earlier, that the violent habitual felon is very infrequently used. We did just look at all of the violent habitual felon convictions that have been imposed over, I think it was the last 20 years. And it's a very small number, even when you set them sort of all together to look at. I can't remember the exact statistic in terms of the racial composition of all of the violent habitual felon convictions, but it was definitely, I think at least 2/3 non-white were convicted as violent habitual felons. In terms of the sort of regular habitual felon convictions, we have not looked at the racial composition of those convictions, but we certainly could. That's a much larger group, obviously, compared to the violent habitual felons, which we maybe see one conviction for violent habitual felon, you know, annually, and there isn't one every year. So it's a very small number. But for the regular habitual felons, we hover, between 700 and 900 sort of historically. So if there was interest in looking at the racial composition of those convictions, we would be happy to provide that for you all.
Yes, please.
Thank you.
Thank you. Excellent. So we are right on time, knowing that we had a full discussion. I will ask you guys to complete the collateral consequences survey if you've not already done so. I believe only 2 of you have done that so far. With respect to fines and fees, we got the feedback from the task force on the straw poll. About 12 people voted. They had overwhelming support. I invite you to go in there and read those comments if you'd like. They're very minor red line edits. And with respect to the prison recommendation, if you guys bear with me for 2 seconds, I will pull up the feedback on prison discipline. And because I've made some red line changes, and I think Mary would like to discuss some of them. But we basically, just to summarize the red line changes real quick, provided a little bit more detail with respect to what the Mandela rules are. And then specifically also added provisions that would end because this was part of the Mandela rules, specifically end restrictive housing for indefinite periods of time and for also periods of more than 15 consecutive days. Under the Mandela rules, that has been prohibited. And the Mandela rules are the United Nations standard minimum rules for the treatment of prisoners. And so then going down, and Mary, did you want to speak on that real quick? Because I know that was in response to some of your comments.
Yeah, so I should have paid more attention to this earlier on as it developed, I guess, but I think there's, on the one hand, I want to say that I know the Department of Public Safety is working hard to sort of make some changes in how they keep people in long-term segregation. But I think in terms of these recommendations, we need to make it really clear that they can, whatever they want to call their high status or high control custody level, they can call it restrictive housing, they can call it anything. But it shouldn't and can't involve keeping people locked down in a cell by themselves 22 hours a day, 7 days a week. That's just wrong. So I just would like our recommendation to put a cap on that sort of isolation, right? Obviously that they're going to have folks that they need to have higher control status, but there's ways to do that without keeping people in those cells 24/7. Colorado has done it. Mercedes has linked to an article I've provided her, and I've actually talked to that former superintendent of the Colorado prison system who's discussed in that article. He put himself in a solitary confinement cell for a couple of days and wrote about the experience. It was in the New York Times and published elsewhere. And at the end of the day, Colorado will no longer keep somebody in that sort of solitary confinement for more than 15 days, right? If they have to do it for safety or security reasons, they have to do it, but then they figure out how to have a more humane housing situation while still addressing the underlying or the behavior. So I just wanted to be real clear about getting people out of those parking spot size cells and having some human contact. So I don't know, Mercedes.
What's that? No, it was so. I'm not sure that the red line changes addresses the concerns as specifically as you have them. And I wonder if you want to do that, or if you want to make those statements in maybe our in the future, like the vision future statement, or maybe as part of the problem statement. If you think that maybe that would encompass some of the concerns.
Well, I thought the red line I thought defining, if the Mandela rules mean that you can't do that, then we're incorporating the Mandela rules. I thought we were in a better place on that.
I think so too. And I think what you're describing, I think we can describe in the vision future statement portion.
Okay.
Mercedes, I would like to have in the problem statement a sentence or two about from some research project. I mean, there's so much out there.
Definitely, we will definitely.
regressive and harmful and inhumane and these practices are. I mean, I'm not singling out our post because I think we're probably ahead of the curve, but just in general.
We will definitely be developing this this problem statement. This was kind of some placeholders, knowing that we have a lot of information and we have are working with a team of people to kind of help with developing these. But I'll definitely include that and then MP's comments as well in our future statement. So those are just little placeholders for that. So keeping on going down, we had some feedback from a task force member, Kerwin Pittman, and I included some of the red line changes with that. And I don't think they changed the meaning as much as just develop them. We talked about develop and expand in mental health treatment with a strong emphasis on cognitive behavioral models and the use of therapeutic diversion units. I think that's probably a best practice and good to be specific in that respect. We've also got down here, when we review the procedural due processes of people accused of infractions, creating a tracking system to monitor the decisions by individual hearing officers in order to monitor for biases. So I think that's a matter of kind of the data collecting in order to make sure that the process is reviewable.
I think there was a lot of encouraging words that Commissioner Ishii shared with us during his presentation. I thought one of the challenges that Ben Finholt sort of identified in his questioning was this need to expand certain programming. And whether it was the gang intervention or whether it was the restorative justice programs, we could all agree that these were good and productive programs. And then you learn that, well, there's only one program available at one facility that can interact with 100 prisoners, and you've got a population of 30,000. Or there's one institution in Asheville that is implementing a restorative justice program, but what about the other facilities? What about the 30,000 other places? So I think there's a lot tucked into the recommendation that that there be expansion of these programs. And these recommendations don't really specify, and not that we can't specify with a whole lot of detail what the nature of that expansion is. But I thought the sense during that presentation was these programs needed substantial expansion, and that there was a lot of good experiential information and data about the success of the programs, and what was lacking was the capacity to make it available to more within the system. So, that's clearly a recommendation that will require additional input and teeth in the implementation stage.
Right. And so these have gone to the task force they've gone to the task force for a straw poll. And so I guess the next step would be finalizing them such that they would be put forth to the task force for a final vote, I believe, by our November 6th meeting. So I don't know if we want to talk about that. I think probably best offline. I'll bring us back to the PowerPoint. And I think some next steps, in my opinion, would be for the working group to review the line edits to fines and fees. Also working on finalizing the line edits for prison discipline, and then taking the collateral consequences survey. And in addition, I have some notes here that we're going to look at adding recommendations regarding felony murder and wordsmithing our habitual felon recommendation. And that's a lot. I think we did a lot today, I think.
Also, in terms of next steps, I'd like to give a heads up about our next session, which is Thursday, November 5th. And much of that group session will be focused on the death penalty recommendations. And I've gotten a fair bit of feedback, informal and formal, on the template that I distributed. I do plan on redistributing a second template, so probably in the next day, certainly by tomorrow. So I am sort of encouraging as much comment and interaction offline about that. Telephone calls, questions, emails would all be really well received. But there will be another edition of that template coming by the end of the day today or midday tomorrow. Any closing thoughts or questions from the members? Representative Morey, are you still with us? I know that you had to jump early.
Yes, I'm here.
Thank you for sitting in with us. Can you let us know what Working Group 3 is working on, and if any of that would be helpful for us to take some advanced look or to participate in your deliberations?
Yes, I think there's a great parallel between our two working groups. I think we're going more to what the courts are trying to do and also look into restorative justice. We're taking a deep dive into recommendations about juvenile life without parole and following up on what you're working on. So we will share some of this. We have our working group meeting tomorrow at 4 o'clock, and we're going to get into more of these issues, including bail, pretrial, and we will be in touch.
Excellent. And I do think there's both overlap in some of the scope of activity and some of the experience that members on Working Group 4 would be happy to share and participate with you on that. So thank you for your participation this morning, and we look forward to staying in touch and coordinating between the two groups.
Thank you to Mercedes, Ellen, and Jasmine.
Wow, what a productive work group this morning. Thank you all. Okay.
Good day.
Have a good week.
Take care, everybody.
Bye-bye.